In this video, I want to continue sharing some tips with you young lawyers out there on how you can become a better medical malpractice trial lawyer. Today's topic, what you need to know about getting an autopsy report and the findings of an autopsy report into evidence. Hi everybody, my name is Frank Spector. I'm a medical malpractice lawyer in Maryland and in D.C. I've been doing this for over 33 years. During that time, I've had the privilege of representing thousands of people and helping them get the justice and the compensation that they truly deserve. I was also an adjunct professor at my law school, so the things that I'm sharing with you are the same things that I've shared with my students. If you're new here, please hit that like and subscribe button. That way you can take advantage of all of my free videos. Autopsy reports come up in wrongful death medical malpractice cases, and they are an important piece of evidence. And here's what you need to know. It's a two-step process. So that's obstacle number one. So you're able to use all of the autopsy findings, all the facts that are contained in that medical record. You can use them with witnesses. They will go back to the jury. The jury will be able to read those factual findings as to what the autopsy revealed. But here's the rub. At the end of an autopsy report, there is usually the opinion of the doctor performing the autopsy, the opinion as to the cause of death. Now, just because an autopsy report has been admitted into evidence, many times the other side will say, we don't have any objection to the autopsy report being admitted, but the area where it says opinion, that has to be redacted, that has to be blackened out. The jury shouldn't see that. And if the plaintiff wanted that information to go to the jury, they need to call the doctor to testify as to what the doctor's opinion is. The fact that it's written on the medical record isn't enough. It's hearsay. And you know what? The other side's right. Just because you've had the autopsy report admitted as part of the medical records, and that doesn't mean that the opinion of the doctor is admissible. You need to bring that doctor in and ask that doctor on the stand what their opinion is. Now, if you don't do that, you're going to be stuck. If you're waiting until trial and you think that autopsy report and the opinion contained in it is going to go to the jury, you could be sadly mistaken. And what are you going to do? It's too late. You're never going to be able to get the autopsy doctor to come into court because the judge is never going to allow you the time to do that. And therefore, when the jury gets that autopsy report at the end of the case, it's going to have the opinion all blacked out because you didn't take the time to figure out how you're going to get that piece of evidence into court. You just assumed that if the medical record itself was admissible and the autopsy report was part of that medical record, you were good to go. But you're going to find out the hard way that you're not. So what's the lesson here? The lesson is every piece of evidence that you want admitted, you're going to have to determine how that's going to happen. And if you don't, you're going to have a lot of egg on your face. I hope you found this information valuable. Thanks for watching. I look forward to seeing you again soon.